Thank you, Madam Speaker. It's always a daunting task to be the last speaker for the opposition at 1:30 in the morning. But the importance of this bill is such that even at these early hours of the morning, the majority of MPs are present. And I have to show my appreciation to the Honourable Prime Minister, who made it a point today. He doesn't do that all the time, but he stayed here and listened to all the speakers. And I hope that, unlike some of his colleagues, he has appreciated the genuine, not demagogical, the genuine concern that we on this side of the House has. Essentially, we are objecting on the form and on the substance. On the form, we have from the government said that, you, the opposition, had 3 days to study this bill. There's only 3 sections that is being amended. What more time do you need? Madam Speaker, we are paid to work, and we work. And you had appreciated the quality of our intervention, showed the amount of work that we have put in these 3 days. But when we asked for the adjournment of the debate, it was not for opposition's sake. It was so that this House can hear what the aggrieved parties out there has to say. What the spouses who have married non-citizens and suddenly find themselves with a sword on their head, what these spouses have to think. When we asked for an adjournment, we wanted to give time for experts in human rights, because even the Attorney General talks like if he's an expert on human rights, and I'll come later to show that even the European Court of Justice has stated that immigration law can be struck out as being against Section 8 of the European Convention on Human Rights. So that we have given time to stakeholders, to human rights activists, to lawyers who specialize in human rights to come and give us the benefit of their thoughts and maybe improve on this piece of legislation. But unfortunately, the only answer we had is from the Honourable Deputy Prime Minister that, we are used to having certificate of urgency, and therefore, it's at the whims and fancies of the leader of the House to choose whether to put a certificate of urgency or not. Madam Speaker, on the form, we on this side of the House, we object to both the amendment which tried to extend the list of prohibited immigrants, and this amendment which makes the residence of a spouse conditional upon him or he not being a prohibited immigrant at the time he or she married a Mauritian. Now turning to the first proposition, the proposed amendment to Section 8, which is introduced by Section 4, subsection B of this bill. Now, as the Honourable Deputy Prime Minister rightly pointed out, any immigration matter, any restriction on an immigrant, on a person to come to Mauritius, is a restriction on freedom of movement. And we have conventions we have adhered to, we have it in our constitution, but even for non-citizens, we have convention to which Mauritius is a party, the United Nations Declaration of Human Rights, of different conventions. But listen to a lot of members from the other side, Madam Speaker. I think that they all have forgotten who we are. Who are we, if not descendants of immigrants? There has never been any indigenous population in Mauritius. We don't have Bumiputers. We don't have Aborigines. We all are descendants of immigrants, whether our forefathers came as settlers, or as slaves, or as coolies, or as traders. We are all immigrants. And if the government of those days had listened to speeches of Honourable Gayan, to Honourable Ratna, to Honourable Deputy Prime Minister, maybe today we wouldn't be here. Maybe today our immigrant parents, forefathers would not be allowed here. Maybe our mothers and fathers would not have been able to marry immigrants. This is the truth. We are. And I think we should take pride of it. If people everywhere, if people cite us as example, if everywhere we are the rainbow nation because of our cultural diversity, because we all are immigrants from different parts of this world. And we should treasure that, and we should not forget when we prevent someone from coming to this blessed land of ours, that our forefathers came to bless this land as well. So, other members, do you know how the forefathers were? Do you know where they come from? Do you know what they were involved in?
No private conversation, please.
Madam Speaker, as many orators have pointed out on this side of the House, the Immigration Act already gives very wide powers to the Prime Minister. In fact, I would say draconian powers, and rightly so. Rightly so, because I totally agree that every sovereign nation has the right to control its territories and who comes in and out. But the point that we're making on this side of the House is there is enough powers already in the hands of the Prime Minister as the law stands, and there's no need to amend it further. The draconian power in the hand of the Prime Minister is in Section 6, subsection 1 of the Immigration Act, which gives him the power, where he's satisfied that it is in the public interest to do so, he may, in his absolute discretion, deprive a resident of his status of residence. And when we talk about resident, we include non-citizen residents as well. This is the draconian power in the hands of the Prime Minister. But this draconian power is subject to one very important caveat. He can only exercise this absolute power if it is in the interest, if it is in the public interest to do so. And this is the big safety net that we have. It has to show that it is in the public interest for him to deport someone who is a resident in Mauritius. But today, with the proposed amendment in Section 4B of this bill, we are getting rid of that caveat. Because today, the Prime Minister, if this bill goes through, the Prime Minister, acting on advice or information, will be able to prevent a person from becoming a resident if, in his opinion, that person would be persona non grata, would be an undesirable inhabitant or undesirable visitor. Now, previously, this person, if he was an undesirable person, he could have been chucked out if it was in the public interest to do so. You have to demonstrate it is in the public interest to expel an undesirable person. But with this amendment, no. Even if it is not against public interest, the Prime Minister, in his own whole discretion, absolute discretion, can choose to deport a person, and now to deport, if the bill goes through, a spouse, a husband, or wife of a lawfully married Mauritian. Now, what is reliable information? It's not this field. Is it objective? Probably not. It's subjective. Who can advise the Prime Minister? Anyone can advise the Prime Minister. Can it be advice from local people, agents, from the Secret Service? Can it be from Secret Service of foreign countries? Can it be Mossad? Can it be KGB? Can it be CIA? Can it be Donald Trump? Is that reliable? And what is the meaning of undesirable? Honorable Senator Ambou said that we have to give the word undesirable its ordinary dictionary meaning. But is the Honorable Senator Ambou aware that there's already a defined term in the Deportation Act for undesirable person? It means, and I quote, a person who is or has been conducting himself in a manner prejudicial to the peace, defense, public safety, public order, public morality, public health, security, or good government of Mauritius. So there's already a definition which is objective, because you have to establish that the person has conducted or is conducting himself in a manner prejudicial. But here, no. No definition of who would be an undesirable person. Wide open. Wide open. It's the Prime Minister who decides who would be an undesirable person. And it is why this side of the House, we are troubled. Because, as I have stated, any restriction, any decision to call someone a prohibited immigrant is a restriction on freedom of movement, and is a restriction that we have to justify to our international partners when we decide to exclude one of their representatives, but also it has to be justified in a democratic state like Mauritius. So with that definition of undesirable, this lack of definition of undesirable, pass the test of constitutionality? Maybe not. So, Madam Speaker, the problem with the lack of definition is that there can be a risk of abuse. And an example of the risk of abuse has been given by, and cited many times by many orators here, is the case of Jogi and Medagama, which I'm not going to propose to deal with extensively. Suffice to say, to remind, just for the sake of people who were not in the House, that it concerned the deportation of a woman who was 8 months pregnant on the eve of the date on which the case was being heard. But what I would like to correct is what the Honourable Deputy Prime Minister said. And I found it really sad that he said it on such an illustrious gentleman as Mr. Robert Annie, former justice, who is no longer here. And for me, it's the second time that in this House, this gentleman is being attacked. The Honourable Deputy Prime Minister said that Honourable Annie did not resign because of the case. He said he resigned because he was not agreeable, because the DPP did not intervene. This is what you said. This is what you said. But let me tell you what happened. Let me tell you what happened, in fact, and what you haven't said. What you haven't said, Madam Speaker, what the Honourable Deputy Prime Minister did not say, is that following this case, there was a PNQ. There was a private notice question in this House, and in this House, when honourable members on the opposition was questioning the Prime Minister about the right of this child. Forget about the mother. The mother was someone who was unfit, according to the Prime Minister, to remain as a resident. What about the right of this child, of the Mauritian going to be born? You know what the Honourable Prime Minister then said? That was in July 1937, July 1993. It was Sarno Jagnat. Okay? She said, I have said she was bearing a child. Nobody knows that the father is a Mauritian. Nobody can prove that. And then he goes back and says again, because it is yet to be established without any doubt whatsoever that the child she is bearing has been fathered by a citizen of Mauritius, because it has always been clear that she has been leading an immoral life, and who knows, a foreigner could have fathered the child. That was on the child. But then the Honourable Prime Minister did not stop there. She went and had a direct attack on Robert Annie. And this is what he said. I am sorry to say it, that the judge in the first instance had interfered with the work of the executive in the case I quoted. When he was approached by a person, he took the liberty on himself of telephoning and giving instruction to the police and immigration office. That was the reason. Because the Prime Minister in this House attacked him, attacked his integrity. And 3 days later, Madam Speaker, so that we have the complete picture of what happened to this and led to the resignation of Mr. Ani. 3 days later, on the 3rd of August 1993, the then leader of the opposition, Navin Ramgoolam, moved for an urgent matter. He was denied this. And then he moved for the following. This assembly direct Mr. Speaker to expunge from the Hansard all unwarranted offences and disrespectful words uttered by the Right Honourable the Prime Minister at the last sitting of the National Assembly, which word constitute an attack against the provision of Standing Order 41, against the confidence and integrity of Mr. Justice Ani and the judiciary of a whole. And when asked about the urgency, this is what Dr. Ramgoolam said. I can just mention that it is an urgent matter because the judge retirement is imminent. This is the truth. Not because he has a quarrel with the DPP, it's because he was attacked, he was defenseless, like he is today. Attacked, his integrity attacked by this House. So I thought it was important that we set the record straight because Mr. Robert Ani did not deserve the treated meted to him. Madam Speaker, we are not agreeable to the proposed amendment to deprive a non-citizen who is a spouse of a citizen of his or her residence simply because at the time of the marriage, he or she was a prohibited immigrant. And I listened carefully to members on the other side, whether it is Honourable Anil Gayan, Honourable Sina Tambour, and very, very forcefully the Attorney General. This amendment is being brought about to cure the Marguerite case. I don't have any problem. I agree that a person who is a prohibited immigrant should not be in a better position simply by marrying a citizen of Mauritius. I have no qualms about that. But don't tell me that it is because of this case that we're proposing this amendment. Because if this is the case, I would have very serious reservation about the legal thought process of the Attorney General. Why? And I say so because if you read Honourable Attorney General, Honourable Anil Gayan, who is a senior counsel, if you read Marguerite, and he has read it extensively, except for the most important part, which is the conclusion. The above provision shows clearly that it does not apply to residents. That's fine. And then the crucial part, which is omitted by everyone. No doubt, it is open to the first respondent, the Prime Minister of Mauritius, in his absolute discretion to deprive Mr. Uteem of his status of resident should he be satisfied that it is in the public interest to do so. Can't be clearer than this. The judge already tells you you have this power, Honourable Prime Minister. If you think that it is in the public interest to do so, you can revoke his residence permit. Did the Honourable Prime Minister do so? Did the Attorney General, as advisor to the government, inform the Prime Minister that he has the right under Section 6, subsection 1 of the Immigration Act to deport this gentleman? And today he comes here and says that we need to amend the law. The public will see who wants to work for them, who wants to work against them. You already have this. It cannot be for that reason. It cannot be for that reason because the Prime Minister already has the power. And this is the judge who says it, not me. I'm humble enough to bow to a decision of the Supreme Court, unlike the Attorney General. So, Madam Speaker, there is absolutely no reason to put families in jeopardy just on the case of Marguerite. Madam Speaker, if the Honourable Attorney General had more time to look at this case, maybe he would have seen the fundamental issues that are being raised by this amendment. The first fundamental issue is something that was referred to, in fact, by Honourable Mr. Justice Robert Ani in the case of Jogi and Medagama, when he said, and I quote, There is, of course, no need for me to make any pronouncement on the very interesting issues raised before me, namely, first, whether in spite of the language used in the Immigration Act about the minister's absolute discretion to deprive a non-citizen of his status of residence and thus cause him to be deported, the person so deprived cannot in the same time challenge the minister's decision before a court of law. So this is the first issue. Second, and this is most important, whether the minister may, by deporting a non-citizen, also deport the child whom she carries when this child will, according to the laws of Mauritius, be born a Mauritian. This is still a valid issue. If tomorrow the Honorable Prime Minister finds that a wife of a Mauritian is a prohibited immigrant and decides to deport that wife under the new powers given to him. And if it happens that this wife is pregnant with a Mauritian child who will be born as a Mauritian national, can the Honorable Prime Minister deport the child also? This is a fundamental point, which, unfortunately, Honorable Justice Robeani did not have time to consider, but this can be raised anew. The Honorable Portab and the Attorney General also, and Honorable Senator Ambou, make a mockery of the fundamental human rights issues involved. I'm not an expert in human rights, Madam Speaker. And I have to say that it's only in the 3 days that I've had to prepare this case that I've done some research. Research on the internet. I contacted some of my friends who are experts in these type of laws who gave me some hints. And actually there's at least 4 potential grounds to contest this law on human rights issues. The first one is the right of privacy and family life, which has been alluded to by the Honorable Attorney General. Article 12 of the Universal Declaration of Human Rights states, "No one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attack upon his honor or reputation." Everyone has the right to the protection of the new law against such interference and attack. So already, you can't attack a family, you can't attack the honor and reputation by just calling him undesirable. Maybe you're attacking his honor and reputation and you're going against Article 12 of the Universal Declaration of Human Rights. There is very similar language in Article 17 of the International Covenant on Civic and Political Rights, Article 11 of the American Convention, Article 16 of the Convention of the Right of the Child, Article 10 of the African Charter on the Rights and Welfare of the Child, Article 8 of the European Convention, which has been referred to by several members, provide everyone has the right to respect for his private and family life, his home, and his correspondence. There shall be no interference by a public authority with the exercise of this right, except such as in accordance with the law and as is necessary in a democratic state in the interests of national security, public safety, etc. And I totally agree with the Honorable Attorney General when he referred to the case of Y. But what he doesn't say is that the European Court of Human Rights has also interpreted Article 8 to provide fairly robust privacy protection, generally and specifically to protect family integrity against state interference. The right to cohabitate with one's family has been held to be a central aspect of family life under Section 8. And more importantly, the European Convention on Human Rights, the European Court of Justice, has found that the removal of a person from a country where close members of his family are living may amount to an infringement of the right to respect for family life as guaranteed by Article 8.1 of the Convention. So when you're going to deport one parent and dismantle the family, it can be against Article 8 of the European Convention on Human Rights. And the court has gone further and said Factors to be taken into account in this context are the extent to which family life is effectively ruptured, the extent of the ties in the contracting state, whether there are insurmountable obstacles in the way of the family living in the country of origin of one or more of them, whether there are factors of immigration control or consideration of public order weighting in favor of exclusion. So it's a balancing act, but it can, on the facts, amount to a breach of Article 8. Then the next fundamental right that may be offended is the right of a child. Honorable Oro-Perot referred to the convention, the African Charter on the Rights and Welfare of the Child, Article 19. It's also reproduced in the Convention on the Rights of the Child, a 1989 convention. Article 9.1 provides as follows. State parties shall ensure that a child shall not be separated from his or her parents against their will, except when competent authorities, subject to judicial review, determine, in accordance with applicable law and procedures, that such separation is necessary for the best interests of the child. So is it in the best interest of the child that the father should be deported or the mother be deported and the child stay in Mauritius? That can be challenged under the Convention on the Right of Child. Then there is the right of parents. As a correlation to the right of children, parents also have the right to be with and the care of the children. So that's the third type of rights that can be affected. The fourth type of right, the right to marry. Article 16.1 of the Universal Declaration states men and women of full age without any limitation due to race, nationality or religion have the right to marry and found a family. They are entitled to equal rights as to marriages, during marriage and its dissolution. Now what we're doing here is we're creating two types of marriage. A Mauritian can get married to an alcoholic who is a Mauritian, or to a drug addict who is a Mauritian, or a criminal who is a Mauritian and stay in Mauritius. But a Mauritian cannot marry an alcoholic who is not a Mauritian, or a drug addict who is not a Mauritian. So there can be a discrimination under Article 16. I'm not the one saying it. I'm just saying that these are experts in human rights who say that there is a breach of Article 16.1 because it discriminates against marriage to non-citizens. This is the law. This is human rights. You're laughing, but maybe if you had time to study the point, you would have seen that there are judgments in cases of Section 16.1, Universal Declaration of Human Rights. Madam Speaker, it is not the Honourable Attorney General invited people who were not happy with this bill to go to United Nations Human Rights Committee and whatnot. But if this is done, this is not going to be the first time that this Immigration Act is being called upon, that the United Nations Committee is called upon to adjudicate on the constitutionality, on the validity of Immigration Act. Honourable Anil Gayan referred to the amendment in 1977 to the Immigration Act and to the Deportation Act during his speech. What was this act, the Amendment Act, about? That Amendment Act deprived a husband who was married to a Mauritian, a non-citizen husband who was married to a Mauritian, from having the status of a resident. Whereas the Act allowed a non-citizen wife to be resident. And Honourable Shirin Omiruji-Zifra, as she was then, together with 19 other women, went all the way to the United Nations Human Rights Committee. And there was a decision in their favor. notwithstanding all the mockery from the other side, there was a decision. And what was this decision, Madam Speaker? The decision was accordingly, the Human Rights Committee, acting under Article 5, blah, 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 of the view, is of the view that the fact as outlined in paragraph 7 disclose violation of the covenant, in particular Articles 2.1, 3, and 26, and Articles 17.1 and 23.1. And then it goes on before that to explain that the committee notes several infringements. First, the relationship to their husband clearly belonged to the area of family as used in Article 17.1 of the Covenant. They are therefore protected against what that article called arbitrary or unlawful interference. The committee takes the view that the common residence of the husband and wife has to be considered as the normal behavior of a family. Husband and wife must live together. Hence, and as the state party has admitted, the exclusion of a person from a country where close members of his family are living can amount to an interference within the meaning of Article 17. So maybe if you had more time to study this bill, Honorable Attorney General, maybe you had read it. Maybe you have seen that we are not only stupid people. Maybe Honorable Sanitambou would have known that he doesn't have la monopole de la connaissance et de l'intelligence. We may be not intelligent as you, but we're not stupid either. We are paid to do the work. So listen to us when we tell you that there are constitutional issues. There are certain issues. And when this bill was passed, Madam Speaker, when this, the Human Rights Commission, the Human Rights Committee stated, the committee accordingly is of the view that the state party, Mauritius, should adjust the provision of the Immigration Amendment Act 1977 and the Deportation Amendment Act 1977 in order to implement its obligation under the covenant and should provide immediate remedies for the victims of the violation found above. Directing Mauritius, because what was done in the Immigration Act then was against the covenant on civil and political rights. And I wouldn't be surprised if tomorrow, on the right facts, a spouse go and challenge what we are voting today as being against Article 17 of the Covenant on Civil and Political Rights. Madam Speaker, I said that there are two aspects of the amendment that we are against. As the Honourable Béranger said in the beginning, we are all in favour of the amendment to Section 8A and Section 8C of the Immigration Act, because it has the effect of eliminating a discrimination against people with disabilities. And in fact, we're just complying with our obligation under the United Nations Convention on the Right of Persons with Disabilities. But then again, Madam Speaker, when I look at the bill, emission bill, my first reaction was, I thought that there were pages missing. Honorable Attorney General said only 3 pages out of these 2. I have this impression. Why? Because there's one section that I would have expected in this bill which is not here, which is the consequential amendments. Had the people in the government, had the Honorable Attorney General advising the government, had time to think that we had to change other laws to give effect to this one? Let me say one, Deportation Act. Deportation Act. We are amending the Immigration Act to say that we're eliminating discrimination against people with disabilities. But in the Deportation Act, the Prime Minister, if he thinks fit, can make a deportation order in respect of a destitute person. And who is a destitute person? I'll read. Destitute person means a person who is or is likely to be a charge on public fund by reason of mental or bodily health or insufficiency of means to support himself. By mental and bodily health. Honorable Sinatambu, Minister for Security, you didn't see that? You're bragging about rights of people with disabilities.
To the minister.
Yes, I will address because I don't want to address you. You have just made a fool of yourself. You're so intelligent that you didn't know that you have to amend the Deportation Act.
To the chair, not to the Honourable Minister.
Yes, because the point I'm trying to say, Madam Speaker, the point I'm trying to make is that if this bill was not rushed through in Parliament, maybe people would have time to think that you need to have consequential amendments. That when you're changing the Immigration Act, you need to change also the Deportation Act. Because it said nothing to say that a handicapped person is not a prohibited immigrant, if under the Deportation Act, the Prime Minister can still deport him. That's an inconsistency. But, you know, this government knows what it's doing, apparently. Madam Speaker, I will end by quoting from the debate. The Honourable Attorney, the Honourable Anil Gayan, in his speech, quoted extensively from Hansard, from the debate, when the Immigration Act was amended in 1977, and what Honourable Mohamed, the father, said. But I will end by what the then leader of opposition, Mr. Anirudh Jagannath, as he was when, no, he was not yet Saj. The then leader of opposition stated, and I will quote, "We know that many persons will be at the whim and caprice of the minister after this piece of legislation will be in our statute book. We know, I repeat it, we fear that this piece of legislation is not going to be used judiciously, especially when we are nothing in the, when we see nothing in the law which will ultimately protect any visiting individual, give him at least a right of appeal or the right to have a recourse against the decision of the minister to a court of law." I rest my case.